Good afternoon. We'll begin in just a minute. Okay, good afternoon and welcome everybody. Thank you for joining us today. My name is Katy Montgomery and I serve as the Executive Vice President at Cyber Defense Labs. Our team of experts work closely to help companies proactively identify and reduce risk as trusted risk management partners. In particular, we work closely with dealerships around the country who are seeking to minimize cyber risk as their dealership grows and their business environment changes. Our webinar today is designed to help inform auto dealership owners, board members, and executives about the proposed changes to the FTC Safeguards Rule. During this webinar, we will cover a brief history of the Safeguards Rule. We will outline some of the proposed changes to the rule and discuss some of the challenges that dealerships may encounter as they seek to comply with the new requirements. And finally, we'll outline some of the steps that you can take now to ensure your dealership and your business remain prepared. A few quick housekeeping notes before we get started. We certainly welcome your questions. Please use the chat feature on the side panel to present questions or comments, and we will devote time at the end of the presentation to answer as many questions as we can. If for some reason we don't have time to get to your question, rest assured we will call or email and reach out and help you answer the question that you proposed. Everyone attending the webinar today will also receive an email from Cyber Defense Labs with additional information and resources about the Safeguards Rule itself, as well as a link to the recording of the webinar. So should you want to review it again or share the information with your colleagues, you'll have that at your disposal. Now, in order to get started, I would love to introduce our panel of experts. We have Bruno and Janalyn Schreiber. Bruno is Senior Counsel at Cyber Defense Labs. She is an accomplished lawyer and investigator with more than 30 years of private sector and government experience, advising senior executives, leading complex enterprise legal initiatives, and creating effective strategies to mitigate and overcome complex and challenging issues and incidents. She has extensive experience navigating privacy, confidentiality, and other important issues and concerns pertaining to cyber threats and cyber attacks. We're also joined by Janalyn Schreiber. She is the founding partner of Data Privacy and Security Advisors. She has nearly 25 years of experience as an expert navigating the complexities of managing privacy, protecting data, and helping clients mitigate financial legal risks to their organization. Janalyn's privacy management philosophy centers on helping organizations remain nimble and adaptable in the face of constantly changing global regulations and requirements. I want to thank you both for sharing your time with us today. To get started and kick off this conversation, Dawn, if I could start with you, could you share a little bit of history on the Safeguards Rule itself? Dawn, can you hear us? Give us 1 minute. I think we're having trouble hearing you. There we go.
Thank you very much. Yeah, I think in the context of the Safeguards Rule, the beginning is a really good place to start, even though it's back in 1999 when the Gramm-Leach-Bliley Act was passed, and we'll call it the GLBA to save our voices. That federal legislation required certain agencies to enact rules regarding the protection of customer information for companies, industry, institutions that were subject to those agencies. And so we're talking particularly about the Federal Trade Commission and the institutions that are subject to the FTC's jurisdiction. So in 2002, the FTC promulgated a set of rules regarding the safeguard of customer information for institutions that are subject to the FTC. And those rules were high-level rules about safeguarding customer information. They became effective in 2003. And among the industry that is affected or subject to the FTC's rules are non-bank financial institutions, and that's a mouthful. It covers a broad range of companies and institutions, to include auto dealerships, to include mortgage brokers, to include real estate agencies that engage in some aspect of a financing transaction between the buyer and the seller. It also includes universities, to the extent they assist their students with obtaining financing or engaging in certain federal programs, involved in certain federal programs that provide financing to their students. So a broad range of industry and non-bank financial institutions come under the umbrella of the FTC Safeguards Rule. So what happens between the time it became effective in 2003 and 2019, when it proposes amendments to the rule? Lots of things, right? It's a long time, those 16 years, and then 19 getting us to 2022. Among those things are, we know, tons of cyber activity, tons of cyber attacks, intrusions, loss of customer data, of customer information, exfiltration of customer information, reuse of that information by bad guys on the dark net and other bad places. And so at the same time this is happening, the federal government is pushing out a bunch of information to private industry about how to fortify their systems, providing videos, training manuals, guides, and also bringing enforcement actions like the FTC, saying, hey, this happened at Equifax in 2017 and things weren't shored up the way they should have been. Here's what you should have in place. And so there's lots of guidance that's being pushed out in this 2003 to 2019 timeframe, but the data breaches keep happening, and they keep happening in a way that is pretty basic. Certain basic cyber hygiene activities that could prevent the intrusions were not taken. And so in 2019, the new Safeguards Rule is proposed, and it becomes effective December of 2022, December 9 actually. And this new Safeguard Rule provides way greater clarity as to the types of things that the information risk assessment must contain in terms of what the information security program must contain. It really prescribes the activities that these non-bank financial institutions must comply with.
Well, I appreciate all of that insight and just helping to understand how we got to where we are. Janalyn, if I can turn to you, if you think about this updated rule from a data privacy standpoint, what are some of the key requirements that stand out that you think we should highlight?
Absolutely. Thanks, Katie. So first, thank you for having me, and to everyone who's on the call today. What I think is really important to bring up, and it highlights the kinds of things that Don was talking about, is before we even look at the things that are going to be required by the regulation, things that already are, things that have been sort of enhanced, I think it's also important to start with what data is actually covered by the Safeguards Rule. Because the FTC, like we've seen in privacy regulations and other sector-specific regulations, has got a very, very broad definition of personal data. So this would be, when we're thinking about all of the new requirements that are in place, you have to take a look at the three different kinds of data essentially that are coming into the dealership. That's going to be data that's directly provided by your customer to obtain products or services. It's going to be data about the customer related or resulting from the transaction. And it's also going to be information that you're collecting in conjunction with the transaction. So this is a huge amount of information, and the FTC actually came right out during the rulemaking process and acknowledged it. They said, we know this is broad, and we're actually going to reject a comment that's asking us to make this more narrow to exempt aggregated or de-identified data. They said, nope, it's all in. And so as we look at the requirements that are in place, and as we take it in consideration with what Don said about the increase in cyber attacks, it's really important to remember that personal data is things that we would expect, name and account number and those kinds of information, but it's also information that winds up coming from sort of unexpected places like technical identifiers like cookies and IP address. So just a little something to keep in mind as we look at navigating this, because without question, and as we go now into what's being required, the FTC is absolutely on the path to really driving an increased accountability in people's information, in dealers' information security programs. And as you can see on the slide, it's really kind of split down the middle in terms of some of it is risk management and governance, and the other half of it is much more practical in terms of the how do we implement some of these controls and make the magic happen. But when we look at all of it, the assessments, the program development, the implementation of specific safeguards, the important thing to understand is that all of this has to be memorialized in writing, okay? So these are well-defined programs with well-defined documentation to accompany it. And that's where, when we look at the requirements, there are, I think, 3 big sort of responsibilities that dealerships are now under. And I just want to highlight those 3 of them really quickly. The first one is that information security assessment. Don mentioned it before. This is the foundation for which your program is going to be based. And again, this has to be an assessment that's in writing. And the rule doesn't give us a whole lot of information about what it needs to look like, but there are 3 things that it does say that this assessment has to do. It's got to be specific about how you're evaluating risk. It's got to give the criteria for how you're assessing the security of your systems. And it has to explain how you're going to address the risks that you found. So basically, what are you going to do? How are you going to do it? And how are you going to fix it? And just to sort of put a cherry on the top of that, which is more than enough by itself, the FTC also says that this assessment has to identify all reasonably foreseeable risks. So huge in terms of the responsibility, and when we take into account this needs to be done on a regular basis, you're starting to get a sense for, again, the proof is going to be in the pudding here. The other major documentation initiative that they're putting forward is something that folks that have been contending with privacy regulations are pretty familiar with, and that's a system and data inventory. And I don't mean to be the bearer of bad news, but this is a pretty significant ask of the company, because really what we're talking about with the data inventory, again, it's going to be a written record, is going to be a complete understanding and record of all of the data, the personnel, the systems, the devices, the vendors, and even the facilities that are processing data that's in scope for the regulation. So it's going to be a very broad view of what your organization is doing. But again, if you think about it, when you have the ability now to know where all of the information that you have is, to understand exactly what systems it's in and what vendors are accessing those systems, you're going to have a much better understanding of how everything's connected. And it's at those connection points that we're going to start to see the opportunity for risk to come in. So really, again, key to being able to build out the program, key to being able to also respond to one of the other requirements, which is the need to start deleting data when it's no longer necessary. Companies, dealerships, everyone loves to hold on to data, and the FTC, as well as other regulators, are moving in to see that old data that's no longer needed is no longer kept. And then I think the third, before we turn over to some of the tactical components, the third big documentation intensive component here is the vendor oversight. And it's not new in and of itself, but the amended Safeguards Rule actually requires there to be much more effective oversight. So again, if we think about where risk to an organization comes from, you could have the most secure internal infrastructure ever. But if your vendor has a breach and what gets breached is the data you've entrusted to them, you've got just as much of a problem as if it was your own system. So with this oversight, we're looking at basically a twofold evaluation of your vendors. You're going to need to assess the risk that the service providers that these vendors present to you, to the dealership. And you're also going to have to evaluate whether or not they're actually in position to actually deliver the safeguards, to actually have the controls in place to mitigate that risk that they present. So again, really much more looking at an accountability, a more proactive stance when it comes to having data protection controls in place. And then just a very quick pivot internally, what we have are the training requirements, which actually have upped the amount of training that your information security team needs in order to stay current. The government has been very vocal about understanding that there are a range of threats that are coming, and so the expectation is that your security team is up to date with all of those different threats and potential vulnerabilities. And then on the accountability side, you're going to have a single qualified individual that needs to manage this program, and this person needs to report to the board. So really, again, active participation, increased accountability throughout the organization, from the top down and from the training perspective, from the bottom up. And then John can take us through some of the more tactical side of how we can get this done.
Yeah, that's a lot of information and insights, and certainly knowing where your data is, how it's stored, how it's accessed, how it's shared, all of that, helps inform your risk posture. Dawn, from the cybersecurity perspective, what areas do you want to highlight as well?
So in addition to the quite long list that Janalyn highlighted, but is in fact, the requirements, the Safeguards Rule also requires clear access control policies that only authorized users are accessing customer information. So you first have to do the risk assessment and the inventory to understand where your information is, what your devices are, what devices can access that information, and then figure out whether or not you're providing the appropriate level of access by personnel to that information. And then if you are providing access to the information, you also have to ensure that the access is limited to only that which the individual needs to know for the purpose of carrying out their job. So a couple of different layers there, but again, it's the FTC reaffirming that they expect non-bank financial institutions to understand the data they collect, to understand where it resides and where it moves in their systems, and to understand who has access to it. In addition to the access controls, the FTC is requiring encryption for all data at rest in your systems and data that is in transit that goes external to your systems, not for internal communications, but for all data at rest in your systems and in transit external. In addition, it's requiring multi-factor authentication, which is just basically having more than one password, more than one authentication method for access to your systems. And if you recall from last year, there was a significant utilities hack, and I believe the CEO testified before Congress that they didn't have multi-factor authentication, and folks were I think out of power or electricity or oil for quite a couple days there. And so that's multi-factor authentication. The new rules require continuous monitoring and logging, of all access. And the FTC is going to want to see that you can recreate what may have happened. And that's actually in the comments to the rule in the Federal Register. The new rule also requires vulnerability assessments at least twice a year, every 6 months, semi-annually, and penetration testing annually. And then finally, in terms of just the cyber realm, the new rule requires a written incident response plan, and that written incident response plan must contain certain specified items: the goals of an incident response, the process for response, the roles of and authority of individuals in the organization, your communications plan, potential remediation, reporting, who are you required to report certain kinds of breaches or access to. So a lot of specificity and a lot of new requirements.
And Dawn, just to shore up that one point, when you see these incidents, these real life attacks, cyber attacks happening in hacks where they're not doing multi-factor authentication and what some will call just basic cyber hygiene, just to, when you think about why the FTC is doing this, it is to shift that so that, we're seeing too many of these attacks with too many basic security practices not being deployed. And we feel compelled now to ensure that these institutions are putting these things in place. Is that accurate, or how would you frame that?
There is clearly a shift from suggested best practices, and those are the things I had talked about in that 2003 to 2019 timeframe. Lots of guidance being pushed out by federal agencies, lots of information to help create sort of a baseline of maturity within the country for cyber incidents, and those best practices seem to be not being adhered to or followed, and the breaches continue to occur as recently as last summer, some significant ones for, again, the basic cyber hygiene. And so there's clearly a shift from best practices to calling out bad practices. And in fact, there is the Cybersecurity Infrastructure Security Agency, CISA, has put out a bad practices list. So we're clearly in a new time frame on these matters.
Okay, and just as a friendly reminder, and Janalyn, I can go back to you. We are going to be sharing this information, these slides, as well as a helpful list on how to, understand the safeguards rules, so we don't have to be taking furious notes as you guys share this helpful information. More of that to come. And again, if you have questions on any of these individual points, please put them in the chat room so we can be sure to address them at the end. Janalyn, I just wanted to give you, if you had opportunity to follow up there, it looked like you may have something to say.
Yeah, I just wanted to add to what Don was saying in terms of the fact that the regulators really have moved beyond sort of being tolerant and patient with organizations. In the amended safeguards rule, they have gone out of their way to be very specific about the fact that this needs to be written documentation, which implies, and in some cases, and we see it with other regulations, may also sort of hint at the fact that when it comes time for an investigation, it is well within the FTC's rights to say, show me, at which point you better have that assessment to turn over. You better have that vendor risk information ready to provide, and you better understand where your data is in that data and system inventory, because this is absolutely the types of things that have gone from being what a sophisticated program has into something that is approaching table stakes. I mean, so I just thought that was worth mentioning, because I do think that the tolerance has gone down, particularly as consumer frustration has gone up because it's our data being compromised.
Yeah, absolutely. If we continue along that area a little bit and think about what this means for dealerships, Janalyn, can you start and talk about some of the challenges that you believe dealerships are going to face as a result of the update to this rule?
Absolutely. So, we spent I think we probably could have done a multi-hour webinar just on the previous slide in terms of what the requirements are, what they mean, what they look like. And I think that one of the big challenges dealerships are going to have is that this advanced information security components that now need to be just present as a matter of fact might be kind of new in some ways. And the increased focus on it is going to be a challenge for all organizations, from very large enterprises to much smaller businesses. And I think something that I do want to make sure, because as we've had conversations with different dealerships, I want to clear up a misconception that might be out there. Your vendors and your DMS providers are not responsible for your compliance. In fact, if we think about the fact that it's on you to vet your vendors, if anything, it's almost the other way around. You're not responsible for their compliance either, don't get me wrong, but it is absolutely not going to be something that's going to be pushed from your vendors to you. So the idea of really being proactive and focusing in a way that maybe hasn't been done historically is going to be a challenge, because we also, like I mentioned, we saw the fact that we need to have a qualified individual. The FTC even put that into capital letters, so it's now a proper noun. It's a qualified individual to run this. And with that comes the challenge also of having a regulation with, as much as it's now being required, there aren't really a lot of specific details on how to go about doing that. So like I said, it was interesting in some of the comment period, some folks wrote in and were very frustrated by how prescriptive the FTC was with that information security assessment I mentioned before, where it says you have to identify the risk, you have to be certain on how you're assessing your systems, and you need a plan to deal with it. Some folks thought that was way, way too specific in terms of a requirement. And the other half of the conversation said, that doesn't give me enough to even know where to begin. And so I think understanding how these kinds of requirements are going to apply to your business is going to be a very big challenge, because it should be right-sized. Each dealership's going to look and feel a little different than others. And so making sure that you're able to work with an expert, either an internal or an external expert, that can help you scale to fit your business. And you want to have something that fits now, but also fits when you continue to evolve and have growth and sort of achieve your own operational milestones.
Can I ask, just on that, identified the qualified individual? I think this was an area in the comment period too, where at one point they may have actually said Chief Information Security Officer and then broadened the definition a little bit. Is this an individual that has to be within the dealership? Could it be a third-party service provider? Or how should dealerships be thinking about this?
So it can be either. It just has to be a qualified individual. And it really comes down to what Janalyn was pointing out. It comes down to whether or not the individual who you should currently have coordinating your efforts is qualified enough to understand all the things that we just spoke about and put in effect or implement an information security program consistent with the new guidelines. Or it can be a third party qualified individual. A virtual CISO was discussed in the comments to the regulations, or just a third party external CISO. But the important thing to know is that that individual must still be sort of directed and controlled by the dealership, and it doesn't absolve the dealership or the non-bank financial institution from its obligations of ensuring that that is in fact a qualified individual, that the qualified individual is in fact implementing and affecting what the safeguard rules require.
And then before I move forward, just one more question. Do you guys anticipate what are the potential consequences or penalties or fines, maybe Don, starting with you, then going to Janalyn, that can result for dealerships that are found not in compliance with this new rule? So
historically, in the 2003 to the 2019 period, what we saw were the FTC as a regulator reaching out to the regulated entities, asking for information, as Janalyn mentioned, maybe saying, now in the future, maybe, let us see your plan, let us see your risk assessment, let us see your incident response plan. So historically, they've reached out to the regulated entities in cases where they may have gotten tips or other information and determined that they actually had enough information to bring an action. Enforcement actions have been brought. Most of those enforcement actions resulted in the FTC context in the Safeguards Rule, settlement agreements or consent decrees where the regulated entity agrees to now have this monitor and this service, and a lot of things are taken out of the control of the entity pursuant to the consent decree or the settlement agreement. Going forward, now, but that was during this time period where we sort of had a high level expectations for the rule and not a lot of clear guidance in the rule itself. And the FTC was making what they thought the rule through their opinions, but folks weren't getting on board. Now that we have some clear guidance and clear expectations and criteria for the risk assessment and criteria and expectations for what the incident response plan should be, and mandating multi-factor authentication unless there's an exception that the qualified individual confirms. Now that we have these very specific requirements, it's going to be interesting to see what the future landscape of enforcement is going to look like, because it's no longer going to be, well, did you do this? Didn't you do that? Can we see what it looks like? It's pretty clear it has to look like this. And if it doesn't look like this, it'll be interesting to see how the FTC is going to move forward.
Yep. And in terms of just putting an actual number on it, so in the amended rule, we've got some dollar signs involved. The fines can be as high as approximately, it's just a couple dollars short of $44,000 a day. And when you think about the things that we've just talked about, the odds of being able to stand up an incident response plan in a day, or setting up a vendor management program, or even doing an internal assessment of your current posture, none of these things are likely to be accomplished in a single day's time. So it's not going to take very long for the clock to start ticking and those dollar signs to really start adding up from 44 grand in a day to extrapolating that over weeks or potentially even months to get some of these things up to the level as defined in the rule. So that'll, besides the brand and reputation damage, if you hit the front page of the Wall Street Journal, the fines should be significant motivation to start thinking about doing things now to be in position to meet the compliance deadline in early December.
So and I'll just jump in with one more piece. So as I mentioned, it's not just the FTC that was required under the GLBA to promulgate safeguards rules. Other agencies were as well, to include the Securities and Exchange Commission, the SEC. And if there's any thing to be learned or gained from what their history has been in the past year, 6 months to a year, they've brought several enforcement actions against their regulated entities for failure to have multi-factor authentication, failure to have sufficient access controls. Their Safeguards Rule is pretty similar to the FTC, though they haven't amended it to be as precise as it is now. And in 3 of the most recent cases that the SEC has brought, in each of those, they've resulted in a settlement where the regulated entity agreed to pay in the hundreds of thousands of dollars. And so we're talking about those kinds of numbers. And I think that is an indication of what we might see in the future from the FTC and other agencies that are enforcing the GLBA.
Absolutely. Because the other thing that we've seen, sorry, Katie, to cut you off, and I know you want to get to the next slide so folks know where they can start, but I do, just to reiterate what Don was saying, we've actually heard from the chair of the FTC, and she is absolutely all in on pursuing and enforcing the regs that the FTC is putting out. And the primary driver behind this is, again, the volume of breaches, the extent to which we're seeing consumer and corporate data being compromised at an unprecedented rate, where the weaknesses exist within the organization itself, but also from that vendor ecosystem. And so I think that the level of frustration is high, and the capabilities to enforce in the current landscape is equally high.
Yeah, well, this is a lot of insight, so I want to thank you both for providing all the commentary that you have. I think it's a lot of information to process, whether you're a large dealership with a very mature security program, or you're just looking at where to begin right now. If we think about that, Janalyn, where is the best place to start as you're trying to get your hands around this?
So I'll start pithy and say at the beginning, but the reality is this, as I tell my clients, when you're looking at this kind of a compliance initiative, we all know it's not a sprint, but it's also not a marathon, it's a lifestyle. So what you need to think about is really to start in a systematic way. And the easiest place to begin from a systematic perspective is with that information security assessment. And it's actually technically not new to the Safeguards Rule. The amended rule is just putting much more focus on it, and it's saying do this so that then you can base your information security program on the findings. So the best place to start is to sit down and make sure that you've got a really good assessment in place. Because again, you're going to want to make sure that you have your understanding of where you are now and how you bump up against what the regulation requires. That's your gap. Where are you versus what you're being told you need to do? And then when you have a better understanding of the overall environment, you're going to have a much better time working through that data and system inventory. And I think that these two, again, it's great that they're on this slide because these are absolutely going to be the most work intensive, but these are also the 2 requirements that are going to deliver the biggest bang for their buck in terms of being able to help the company secure the data. Dealers have tons of different kinds of data coming from different areas. You've got paper, you've got digital, and you've got actually environments where that might be combined, where data is being scanned in and things like that. So there's lots of moving parts. Having the inventory in conjunction with the gap assessment is going to give you a very good understanding of the different vendors in play, the different systems in play, and the kind of data that you're working with that you need to ensure that you're protecting. And then after that, it's just a matter of sort of, rinse and repeat. Keep going through it on a regular, sustained basis to demonstrate that ongoing compliance component.
Don, did you have anything you want to add?
In thinking about this, and Janalyn and I have spoken about it several times over the past, week and a half getting ready for this presentation. I think for me, I start even at somewhat of a different place, which would be looking at your qualified individual now. Who is your coordinator, which is what the rule since 2003 has required? Is that an IT specialist? Is that somebody who only understands your devices and doesn't really look at, information security? Are they able to understand the list that Katy will be sending out of, what the new requirements are specifically? Do they understand how they would access multi-factor authentication services? How they would access, how would they map out their network? Do they really have a good understanding of that, or are they just, buying new devices and sending out new devices to the staff? And so identifying who that person should be, I think, is kind of important, and also looking at what were the prior assessments, because there have been assessments, I think, done at most companies regulated by the FTC. And so what do those prior assessments talk about? Do they meet the criteria that Janalyn spoke that the new assessments must meet? Maybe they do, and you may be fairly well along. And then once you take a look at what your prior assessments were, even if they're not in writing, if there are outlines or notes somewhere, then looking at the gaps. Okay, where do those assessments leave gaps? Where does our network and our data inventory that we may have done and we may have a very good handle on, where are the gaps in terms of what the current Safeguards Rule requires? And I think that having that conversation with your current staff that's coordinating your information security program and getting a good handle on it will make you way better prepared for the conversation with, if you do need outside experts for that conversation. Because oftentimes, you're 2/3 of the way there. We at CDL, we see companies that are across the entire spectrum, companies that are at the very nascent stages of developing a cybersecurity and information security program, and those that have a very mature program but just have a couple of gaps. And so I think every company is different, and that's kind of where I would start my path.
And having that proactive conversation, getting this in place, and as these dealerships transform, they go through acquisitions, there's lots of business transformations that are taking place in this industry. You can proactively think about and have this privacy data security conversation earlier as part of your business strategy as well. If we have time, let's turn to questions now and be able to answer some of the questions that have come in from the audience. One of the first questions we received was, could you provide a sample ISP, information security plan or program? Is there any more detail we can shed on what are the components that need to be included in that? Don, do you want to start?
Yeah, sure. So a baseline information security program addresses people, processes, process, and technology. And it includes an inventory of your systems. It's basically everything that's in the Safeguard Rule. I think the rule is born out of the prior incidents, and it is intended to assist in creating a strong baseline information security program. So I think we've put together a before and after that has some of the requirements for the current rule as opposed to the old rule. That will be a great head start in putting together an information security program. Plus, in addition, some of the resources that I think we're also going to be sending out, the FTC has a tremendous amount of information on their website regarding for small businesses. What does an information security program look like for small businesses? If you're a larger business, what should it look like? So there's some really great resources out there.
One of the other questions we received, and Janalyn, maybe we can start with you, is what would you envision would satisfy the requirement of, quote, reporting periodically to an organization's board of directors or senior officer in charge of information security? Does it need to be written as well as these plans do? Is it an oral presentation? What type of concern should they be thinking about and making sure they're prepared correctly there?
Absolutely. This is a fantastic question because this is actually the culmination of all of your work would be this very important presentation to the board. And so I think that the way that dealerships ought to take a look at this is to think about it as at least an annual presentation. And to piggyback on what Katy was saying about the fact that there's a lot of growth, there's acquisition, there's movement in business transformation within the space. I think anytime there's a major initiative that's going to be embarked on that has the potential to impact your data, your security, and your overarching sort of privacy posture, your data protection posture, that's when you're going to want to make that report to the board. This would be your qualified individual. This would be the folks the individual that's leading the program, as well as obviously there can be multiple participants. And I think that absolutely there should be a written presentation that is at the core of it. And of course, the format should be a dynamic one to allow for the all-important Q&A component, which is really what this is getting at, keeping the board informed. Certainly, if it ever came time to have to produce these kinds of things from a legal perspective, there will be some opportunity probably for privilege and the rest of it. But definitely err on the side of being comprehensive, because the board's role as a guide to the organization is really much more fulsome if they've got the full picture and understand what's happening on the security side.
And John, just before you answer, because I think there's a piece that you can also contribute to here in terms of the Part B, what happens if the board is receiving these reports and there's inaction at that level? You know, what are the consequences or liability?
Yeah, I was just about to raise that. So I think I heard recently a very good description of sort of, again, the paradigm shift that we're seeing. The expectation of the board is not overseeing the cybersecurity, information security risk, but managing it. And so it's not just a question of providing a document that looks great, seems to have a lot of the boxes checked, and seems to pass the initial sniff test. It's really a question of, is the board ingesting it? Are they understanding what the risks are? You know, from the beginning, the information security, the risk assessment requires board action and activity in determining what level of risk are we willing to accept. You know, what risks are we going to mitigate? What are we going to accept? And having that out in writing. And so I think that going forward, the board role is going to have to be way more robust. I think that's in large part what the Safeguards Rule, the amended rule, is intended to see occur.
Okay, and just one more question before we conclude. Don, we had a question that came in that just talked about, you know, again, those bad practices, I guess, that were being implemented. I think you said that CISA over at DHS has a list of those as well, you know, so we're not only showing, you know, what's the right thing to do, but what is the wrong thing to do and the missteps that are taking that are, you know, resulting in some of these changes to our environment. Can you speak to that again?
Yeah, so a lot of those bad practices are largely the inverse of the good practices, right? Don't have passwords that don't allow your personnel to have passwords that are 1, 2, 3, 4, 5, right? The most recent, there's a study that the World Economic Forum, or a chart that the World Economic Forum pushed out regarding passwords. And if you simply have an 11-digit password that includes uppercase, lowercase, letters and a number, you can eliminate brute force activity for breaking that password to about, I think, 41 years. If you add a character to that, 11 characters, uppercase, lowercase, a number, and a character, pound sign, the @ sign, then it's about 400 years. And so it doesn't take that much to improve some of these, some of our cyber hygiene. And in terms of the password, there's a change, a best practice to passphrase. And what does that mean? That means, I heard someone say once, I want to eat pizza on Fridays at 10 p.m. So it would be uppercase I, W for want, T. So you use the first letter in a phrase as your password, which is a mix of letters, and maybe every other letter is an uppercase. And so you've got a mix now of uppercase and lowercase, and then you put in some numbers. And so using passphrases is a best practice. A bad practice is using consecutive numbers, or only using lowercase letters, or using a birth date, etc. I think I answered your question, Katie.
Yeah, absolutely. I think you both could give a laundry list of examples, and once you get those passwords in place, you know, don't share them widely and make them known across the entire organization. So really good points. This was a lot of information. Oh,
one thing we didn't mention that I would like to, I think it's important to say, there is an exception to the Safeguards Rule. So if you are a non-bank financial institution that maintains less than 5,000 records, information regarding less than 5,000 customers, then you are exempted from certain aspects of the rule. Not all of them, but from certain aspects, the written incident response plan and a couple other. So, you know, it kind of begs the question, though, of, have you counted where all that customer information, do you know where it is and have you counted it? And so that part of the rule is not, you're not exempted from that part of the rule. But the FTC recognized that some entities that are close to that number might want to just delete more often to stay below the 5,000 number.
No, great point. I know we wanted to address it. Janalyn, before we conclude, are there any additional remarks or highlights you want to emphasize?
I think the only thing that I would say is that, you know, like you said, Katy, there's a lot of information here, but the reality is all of it can be approached one step at a time. Please don't be overwhelmed by it. Realize not only is this something that can be done incrementally, but that there are experts like ourselves here to help, and that there is absolutely a path forward, just again, one step at a time.
Yes, yes, and we are certainly here to help. Again, I want to thank you both for the insight, the thought leadership that you have on this issue. It is a very important topic that's going to be with dealerships moving forward. And like you said, we're here to help. If anybody has any questions, want to speak with these individuals or any of our experts, especially if it's specific to your dealership and you just want to talk one-on-one, please contact us or send us an email at experts@cyberdefenselabs.com. Again, we will be sharing all of this information that you've received today with you via email, but there is a tremendous amount of resources also on our website at cyberdefenselabs.com/automotive. And you can sign up to receive additional updates from us. We actually got confirmation that we'll have an FTC official to be on an upcoming webinar that can speak directly to their intent and answer some of these questions as well, so that we continue to educate and inform and make sure that everybody has the information they need to strengthen their security program and be on the right track. Thank you again for joining us, and I hope everyone has a great afternoon.